But this humane approach laid the groundwork for a new, equally damaging form of institutional control. For the first half of the 20th century, courts largely refused to intervene in prison administration, operating under a hands-off doctrine. This began to erode in the mid-20th century, largely driven by the broader civil rights movement and a series of landmark federal court decisions. In 1962, Robinson v. California applied the Eighth Amendment's prohibition on cruel and unusual punishment to state actors. 2 years later, Cooper v. Pate ruled that prisoners could file civil rights lawsuits against state officials for constitutional rights violations. These decisions paved the way for challenges to entire prison systems, with the Holt v. Sarver case in 1970 establishing that the totality of circumstances of an entire prison environment could be deemed unconstitutional. But as courts intervened, a powerful political and social backlash took hold. In the tough-on-crime era of the 1990s, California widely adopted security housing units, or SHUs. These supermax units were designed to permanently separate individuals deemed security risks. Solitary confinement, once seen as a reform, was now used for prolonged, indefinite isolation that was intended to break a man's spirit. The very thing meant to be a humane alternative had been weaponized into a form of psychological torture. This new, legally sanitized form of punishment was met with a new wave of legal challenges. In Madrid v. Gomez, 1995, a federal court found that placing mentally ill prisoners in solitary confinement could constitute cruel and unusual punishment.